All right, let's bring in my guest this hour, criminal defense attorney Jeffrey Wolf. Jeffrey, great to see you, my friend. It's been quite some time since we've done this little rodeo together, but I'm glad you joined me on the program here today. Jeffrey, this is a interesting case here to me because from the get-go, the prosecutors admitted we don't have all the forensic things that are going to tie him to this scene. We don't have the DNA. We don't have a murder weapon. We don't have her DNA on him or inside any of his cars. All of that stuff that jurors are used to seeing. But they do have a lot of this circumstantial stuff that she's combing through, pretty effectively here. But we're in a new day and age, Jeffrey. Do you think this is going over well with the jury? I mean, people want to see that, specific, inarguable data.
Yeah, I mean, jurors not only want to see it, they oftentimes expect it. They expect the prosecution, before they get to the stage of presenting a case to a jury, to have something that is forensic, something that meets that CSI test that jurors often expect. But those things don't always exist in a case. And I think prosecutors do a pretty darn good job in jury selection most times of safeguarding against that as they deselect jurors that aren't going to fit a case like this. They go through and they find the jurors that are going to demand that evidence in a case that doesn't have it, and they get them off the jury. And so those jurors are probably not sitting in that box, I suspect.
Yeah, I mean, that makes total sense here. And Jeffrey, we're also dealing with quite an emotional case, regardless of, who did this. A woman stabbed 81 times. Obviously, that's emotional. That's hard for a jury to carry, especially if there's some young women or even some mothers on that jury, mothers or fathers. I'm just wondering, if that emotional load, the people are human. They're going to have emotional attachments to what they're hearing here. Could that emotional load overshadow the prosecution's evidentiary weaknesses here when it comes to their deliberation?
Prosecution counts on that in quite a few cases. They count on the emotional weight of the case that they are trying to overcome a lot of the weaknesses that can exist in any case that they have, whether it be a low-level domestic violence case, a homicide like we're looking at here, because you're not going to find many homicide cases that are not emotionally heavy,
right.
A sex assault case. They count on that emotional weight and how it plays with the jury. It's one of the reasons that they show the grisly photos that aren't necessarily important to show to a jury. It's one of the reasons that they always want to show those photos, even if the defense is willing to stipulate to the grisly nature of the homicide, because they want that emotion out of the jury, and they count on it to blur the lines of any other deficiency in their case. As a defense attorney, I am well aware of how often they count on that weight.
You've been in that situation a little more than once, huh?
Yeah.
Jeffrey Wolf, stand by. Watching along with us, criminal defense attorney Jeffrey Wolf. Jeffrey, I want to get your final thoughts on the prosecution's closing there. Even without the exact forensics, I think they walked pretty detailed through all the circumstantial stuff. I mean, she's saying these things aren't a coincidence. There's multiple things that they lined up perfectly to me as she was talking.
Yeah, I mean, what did I tell you? How did she finish it, though, right?
Mm-hmm.
With the big emotional flourish of let's look at the burned skate. But I don't know that I've ever heard the term, if something is too big of a coincidence, it's not a coincidence at all. I don't know if that is a well-worn phrase.
A little strong, a little bold.
Yeah. But one of the things that I always hate that lawyers do a lot is when they use turns of phrase that aren't real. If you're going to use something as a well-worn quote, use a well-worn quote that people know. But she did a very, very good job of going through all of the evidence and laying out the timeline. She did a very good job of using demonstrative evidence. Jurors love that, especially if there are young jurors on there. They expect the PowerPoints. They expect the arrows to point towards the defendant. This is all the stuff that he got rid of. And she played the hand she was dealt. Now, I'm a defense attorney. One of the things that I always love to do is I love to say that they have to put a puzzle together, and a puzzle that's missing pieces is not a puzzle that's complete. And so she really talked about how she has a puzzle and all the pieces that it's missing. If there are jurors on there that do puzzles, they're going to say, we have an incomplete puzzle. We do not have a complete puzzle. And so she used a lot of turns of phrases that trial lawyers hate. And she's obviously an experienced trial attorney, or she wouldn't be trying a homicide case and doing the closing argument. But she was very, very folksy in the way she talked about a very, very serious case. And I don't know how much I love that. Now, when cases are tried in certain parts of the country, you get away with that. But I don't know. I didn't, it's not my style.
Right. Should the defendant have testified here, Jeffrey, or do you think there would have been too much of a risk getting sliced and diced on the cross-examination?
Well, here's what I'll tell you. The defendant has no obligation to testify, so I always hesitate to say whether he should have testified or not. Mm-hmm. But I think if he had a story to tell, he should have told the jury that, in the sense that they like to hear from a defendant.
Absolutely. Jeffrey, stand by, folks. Coming up, watching along with us this hour, criminal defense attorney Jeffrey Wolf. Jeffrey, guilty of all charges. Let me just run back through them here real quick. Malice murder, felony murder, assault, arson, concealing a death, evidence tampering. Guilty of all of those things without direct forensic evidence. Clearly that circumstantial evidence was overwhelming to that jury beyond a reasonable doubt. What are your thoughts?
Well, I'll say it here. You'll never see me sitting in a defendant's chair charged with such a thing, but if I ever am, I hope the jury takes longer than an hour and a half to come back with a guilty verdict.
Fair enough. Fair enough.
That was the quickest guilty verdict on such a serious case I have ever seen on these airwaves in a courthouse that I practice in ever. I know people want to get home, but that's a man's life. And I know it's a woman's life that was taken, but that is a very serious decision for a jury to make in an hour and a half.
That's what I was thinking. I mean, I guess we have a 3-day weekend coming up here at Memorial Day. Even, earlier this afternoon when I was informed that the jury would be getting the case or expected to get the case at some point today, I had that same thought, though, Jeffrey. I was like, Friday going into a 3-day weekend. They don't want to take this through the weekend, hanging out with their families, come back on a Tuesday. But to your point, I also agree firmly with that. We're talking about the liberty of a man here, especially with the amount of evidence they had to go through. I mean, like you said, hour and a half. What do you think sealed the deal here? I guess maybe they just accepted the prosecution's argument that his behavior after the killing was a little overwhelmingly suspicious. I mean, you have him fleeing to Louisiana, you have him using this fake name, you have him traveling, pointing strongly towards his consciousness of guilt, regardless of the lack of that forensic evidence.
Yeah, I mean, they had to have bought the prosecution's theory of the case, and they had to have bought it early, and they had to have bought it often, right? Because they didn't have enough time to go back into that jury room and read the jury instructions carefully, consider all the evidence, vote more than once or twice. I mean, they had to have come into that room with their minds made up fairly quickly and taken a straw poll, decided that their minds were made up, and waited out the clock so that they didn't just come back right into the courtroom with guilty verdicts. They had to have pretty much thought he was guilty from the word go. And that means that they didn't buy anything the defense was selling, and they bought everything the prosecution sold.
Do you also think, Jeffrey, I mean, again, 90 minutes, just over an hour and a half, that is just incredibly quick. Talking about malice murder, felony murder. We have 6 heavy-duty charges here involving the murder of somebody, and that was just lightning speed. Do you think the emotional weight of, maybe the 81 stab wounds, do you think that played a major role here? I mean, it seemed like a clear crime of passion, and, 99% of the time when we see a crime of passion, it's somebody who is close to the decedent, i.e. their boyfriend, like the situation here.
Yeah, I mean, it certainly could have. It's hard to imagine a stranger stabbing somebody 81 times unless they have a serious mental illness. And there's, something that you just can't quite understand that could cause somebody to do that. Usually when there's that level of violence, there is a motive to it. But the state didn't even provide a motive. That's the craziest part. She stood in front of the jury and said, "We have no idea why he did this, and we don't need to tell you." She stood there and said that with a straight face. Mm-hmm. And so, I mean, they just connected all the dots for the prosecution without taking the time to talk about it. I mean, I have friends that have sat on juries, and it takes 15 to 30 minutes to pick the foreperson. And they came back in 90 minutes. It's crazy.
They had, like you said, they had to have gone in there already either with their minds made up, or all of them were just kind of in consensus. Guys are ready to go. Let's just make a decision, which is what you hope didn't happen. But, I digress. Jeffrey, stand by. Court is taking. All right, still with us, criminal defense attorney Jeffrey Wolf. Jeffrey, I know you're writhing in your seat at this because it was so quick. But, Jeff, I mean, it seems that the jury is not the only people moving fast here. Clearly, they want to move fast on sentencing. Juries, they're not the only one ready to get out of that courtroom today. They want to do the sentencing this evening.
Yeah, judges often do this in murder cases because there really isn't a lot of options when it comes to sentencing in many states. Unless the death penalty is on the table, it's usually just life in prison, and there's no hope for parole in most cases. And so there really isn't much to talk about when it comes to sentencing in a murder case. So there's not a lot of reason to delay it unless there is going to be a strong presentation from the victim families and they're not present. And so there really isn't a big reason to delay the sentencing, quite frankly. But at the same time, this case is just trucking right along. And I really have a bad taste in my mouth. And I think that, it can be tough. And I know we're here on Court TV, and you read the comments online when you appear on Court TV. And I know that the people will hear me as the defense wonk here, and they will have a bad taste in their mouth that, this justice that was got for this victim here in this case is not something that I am here tooting a horn for. I am happy for her family that they got justice if this is the person that killed her and this jury has said that it was. I don't care if he is guilty of this crime. I think that a trial of this magnitude deserves more contemplation by a jury than 90 minutes. I think that justice that is swift in that manner is no justice at all. And I think that a jury should take their job more seriously than to deliver a verdict in 90 minutes for a trial that has consequences this grave. And I think that they should take it significantly more seriously than they did.
Jeffrey, let me ask you this. I have this thought pretty much with every case that we have here at Court TV, because pretty much all we cover is murder here. When the defense for a defendant here is pretty much saying my client didn't do it. We're not talking about, insanity like he did it. We can see that he did it, but let's try to get him off of death row. When they're clearly trying to say this is not the guy. Okay, cool. That's what defense attorneys are paid to do. That's the job you are supposed to be doing here. Would it have helped if they presented an alternate suspect theory? Like, okay, it wasn't Eugene Jacques, but it was this person. Do you think that would have aided at all in the defense's narrative here?
Absolutely. Having a straw man is the best defense that you can have when you're saying your client didn't do it. So not always easy to know exactly who your straw man is, but it is nice to be able to say, this is a person with, hundreds of thousands of Instagram followers, and anybody could have been obsessed with her and taken action against her. Putting on some sort of defense probably would have been a good idea here. To put on no evidence whatsoever was probably not the best plan. I think that if they had subpoenaed her Instagram data, they may have found some sort of obsessed fan out there that they could have pointed to. Maybe they did that and they couldn't find anything out there. I find that hard to believe. But, to put on no defense whatsoever made the prosecution's job quite a bit easier. You can't just rely on your opening and closing to be your defense to this, and to say that everything's a coincidence is not the best defense to put on when the only thing you have to rely on in reasonable doubt. It's not what the jury wants to hear. Like I said, you have a right to not testify in a criminal case, and that is sacrosanct. And I believe in the Constitution. But at the same time, I always advise my clients that we need to give a jury a why. Why are we right? And if we don't do that,
that's the thing, Jeffrey. They love to know the why. They love to know the why. It's like, okay, we see this thing happen. What's the motive? Who could have been doing it? Was he cheating with this person? Was she doing this, and that? And you bring up a good point, Jeffrey, that I didn't even think about. I mean, she has, over 100,000 followers, 140,000 on Instagram alone, probably more on TikTok. I don't have nearly that many followers, and I get messages and comments of all different assortments from people online. I can only imagine what they would have found if they subpoenaed, like you said, subpoenaed that Instagram data or whatever. They could have pinned it somewhere else, that it could have been this person, it could have been that person. I mean, the metro Atlanta area is a giant place full of all different kinds of people that, like you said, to not put on a defense, that seems a little risky. Clearly it was here. Jeffrey, I've been informed that the judge is back on the bench. Let's go back into that courtroom right now. All right, still with me, Jeffrey Wolf, criminal defense attorney. Jeffrey, life without parole, an hour and a half, just about 93 minutes to put a man away forever. Your thoughts?
Well, I think you know my thoughts, Cody.
I'm beating a dead horse, but I mean, it's going along. But I mean, life without hour and a half, man. I mean, I get it. The circumstances kind of painted a picture here, but as you said, a puzzle without key puzzle pieces isn't a complete puzzle. And they admittedly said, hey, we don't have all the DNA and all that, but here we are. Man's going away forever.
Yeah, I think by the time you and I are done talking about this, it's entirely possible that we will discuss the circumstances of this case for longer than the jury did. And we certainly will discuss it for longer than the judge discussed it with the victim family. I mean, it boggles the mind. It boggles the mind how quickly a black man in the South can be put away for the rest of his life. It boggles the mind. And it's the only place you see it. You know, it just is what we do here in America.
On the flip side, though, Jeffrey, did you think that his defense kind of overplayed the bizarre evidence thing? Remember the pay stub inside the burned car, that this piece of paper just so happened to not get burned up with everything else? They leaned into that, trying to say it was planted, but they were making these allegations without proving any police misconduct, which is it's kind of a bold thing. Like, if you're going to say it was planted, show us a little bit more. Do you think they played too much into that? They leaned too much into that narrative?
Yeah, I mean, there are a lot of lawyers out there that are always looking for their Johnny Cochran or their Matlock moment, right? They want to have the time that they get to point the finger at dirty cops. But if you want to point the finger at dirty cops, you need to have a dirty cop to point the finger at. Not everybody's Mark Furman. May he rest in absolute non-peace. But it's just, you got to do something for your client. You can't just sit on your hands and watch him go away. You just can't. You have to put on a defense. You have to stand up and stand with your client. You have to stand on 10 toes at all times. You have to do it when the prosecution witnesses are on the witness stand. You have to do it when it comes time to mount your own defense. And you absolutely have to do it at sentencing as well. You can't just say, well, my client doesn't have any criminal history, which is what we just heard his own lawyer do. Mm-hmm. This entire system failed this guy, whether he did it or not.
Well, Jeffrey, let me ask you this. Since this was, this entirely circumstantial and admitted circumstantial case, is that easier to present to an appellate court? Is that easier to appeal down the line?
Yeah, he's got a sufficiency of the evidence argument, if nothing else, right? Mm-hmm. I'm not an appellate lawyer, but I know the grounds on which a case can be appealed, and sufficiency of the evidence is one of them. And so when the jury did him a favor too by deliberating for 93 minutes, because when you're making a sufficiency of the evidence argument, and then you can also point in the appellate brief to the fact that the jury deliberated for 93 minutes when they were given the case, at the hour they were given it before a holiday weekend, that is absolutely something that the appellate court can take into account when looking at a sufficiency of the evidence argument. And so,
Jeff, I hate to have to wrap you up, but we're out of time here, man. Thanks for joining us, folks. Join us next week on Court TV.